Good morning, everybody. Thank you for being here with us. I'm Katie Earle. I'm the coordinator of the University Express program, and I work for the Erie County Department of Senior Services. And we're joined here virtually with Sarah Duval, a supervising attorney at the Center for Elder Law and Justice. Welcome, Sarah.
Thanks, Katie. Happy to be here.
Well, we appreciate you. And to everyone who's on, welcome. We are recording this session, and I'll try to post it on the website at a later date if everything goes as planned. And we have a couple new folks on today, so just quickly, we'll be communicating with you through the Q&A panel. So as Sarah goes through her presentation, if you have any questions and comments, go ahead and type it in that panel. So if you're on a laptop or computer, check the lower right-hand side of your WebEx screen. You'll find your Q&A panel there. And if you're on a smartphone or tablet, touch your screen. That brings up your control panel. You'll see a circle with 3 dots. Click on that, and then you'll see Q&A. So we hope you participate and get all your questions answered. So we'd like to thank the sponsors of our program, which is my Department of Senior Services, Blue Cross Blue Shield of Western New York, Excelsior Orthopedics, and Wegmans for all their support. And Senior Services is at 858-8526 if you ever need anything. All right, the star of the show today. Sarah Duval is a supervising attorney at the Center for Elder Law and Justice. She handles cases dealing with elder exploitation and is a frequent presenter on the topic of elder abuse prevention. Sarah is a member of both the Erie and Niagara County Councils on Elder Abuse, the Erie County Bar Association, and many others. She also serves on the board of directors for Lawyers for Learning. She's been published in the New York State Bar, New York State Elder and Special Needs Law Journey, and is the recipient of the Women's Bar Association of the State of New York. And she was the Western New York chapter's outstanding new lawyer in 2015. Sarah, thank you for being here. The floor is yours.
All right. Thank you, Katie, and thank you everyone who's tuning in today. We have, this is a really important topic. To me, it's an exciting topic. You know, power of attorney is one of those documents that's probably most familiar by name to folks, but what it actually is and what it actually does is, I think, something that we could all learn a little bit more about. And I would just encourage you, use that Q&A, use that chat, put questions in. I am going to save them till the end because you never know, they might be answered during my PowerPoint. And also, never hesitate to reach out if you have questions. My contact information will be on the final slide. All right. So, and I'm going to preface this by saying that the timing couldn't be better. The power of attorney law, which is what governs how we draft and, sign and execute power of attorneys, is being updated on June 13th. That's Sunday. So we only have a couple more days for the old form to be in effect. It will still be valid if you've done it. Don't worry. The new law doesn't invalidate any prior POAs. But we're going to go over some of those changes today, as well as more generally what a power of attorney is. Okay. So what is it? Power of attorney is a legal document in which an individual, known as the principal, gives authority to a third party, known as the agent, to perform certain tasks and conduct business on the principal's behalf. The power of attorney document lists the various tasks which the agent is authorized to undertake for the principal. For those of you who have ever seen or looked at a power of attorney or done one yourself, those specific tasks are listed in the grants of authority. And they can range, the most common and most frequently used, I would say, would be to conduct banking transactions. But it can be anything from buying and selling real property on behalf of the principal, all the way to even, conducting business, right? If the principal owns a business, the agent has the right to step in and, conduct business transactions. So if you're ever, looking at, make sure you really read through all of those grants of authority, because there's a lot of them. It goes all the way A through O. There's a lot of grants of authority. But primarily, as I said, it's a document for financial decisions. To make medical decisions on behalf of someone, they need to complete a healthcare proxy. Some states call a healthcare proxy a medical power of attorney. I've heard that term. New York doesn't have a medical power of attorney. We just have a healthcare proxy. So if you want someone to make health care decisions on your behalf, it's a whole separate document. And as I said, agents only have the power granted to them by the document. They are not entitled to determine anything that's not in that document. And this is a pretty common misconception, I would say. So if you appoint someone an agent, there are certain times they may think, well, I'm power of attorney, so I can determine who gets to visit with mom at her home. The power of attorney doesn't do that. It's just really for financial decisions and any specific powers listed in the document. So it doesn't give someone authority to make life decisions and who the principal can and cannot interact with. So just keep that in mind. What are the roles in a power of attorney? There's one principal who designates one or more agents. So there can be, in the document, up to 2 primary agents. And those are individuals who are able to act immediately. And then they can also designate up to 2 successor agents. Successor agents are individuals if for some reason the primary agent or agents can no longer act. When you're executing a document, you can say, well, I'd like, these 2 people to be to do it. I'd like them first. But if for some reason something happens to them and they can no longer act, I'm going to designate a backup. But the successor can only act if the primary agent can no longer or refuses to act. You can also appoint a monitor, someone to check on the agent's activity as power of attorney. This is it's not done regularly, but it is an option right in the document. You can select someone as a monitor. More typically, I think that would be done for people who have a significant number of assets, or they have, a large business, and they just want someone with authority to check in whenever they would need to. So the agents, they're commonly referred to as the power of attorney. Even though the power of attorney is the document itself, people say, well, my power of attorney. And that's, kind of colloquially the agent or attorney in fact. They said they must act on that authority granted to them in the power of attorney document. They cannot exceed that authority. And they must always act at the direction of the principal, or when the principal cannot give direction, in the principal's best interest. This is really important. Well, if you're appointing someone to act on your behalf, they can't just say, okay, well, now I'm the power of attorney and I get to just do whatever I want. No, they have to act at your direction while you're able to give it. And then, the real reason we do these powers of attorney is if for any reason, somewhere down the line, you're unable to give direction, you're able to manage your own finances, there's someone that you've chosen, or perhaps you've been chosen by someone, to act on their behalf. It's a peace of mind. It's someone, we're going to get into how you should choose these agents, but they do have a fiduciary duty to act, again, at your direction or in your best interest. Can't be in their best interest, has to be in yours. Some frequently asked questions. When does a power of attorney expire? At the death of the principal. This document is not valid after the principal dies. Again, a common misconception. We have individuals call after, their mother or father have died, and they say, well, I'm power of attorney, so I need to, to pay the bills, handle the estate, and everything. No. Once the principal passes away, that document is no longer valid, and any sort of authority would transition to the executor of the estate. Also, it expires when it's revoked. A power of attorney can be revoked at any time and for any reason. Certainly, if you disagree with how the agent's handling your affairs, or if there's concerns of exploitation, or maybe the agent moves and isn't as responsive, all you have to do for that power of attorney to no longer be valid is put in writing that it's being revoked and send written notice to the agent for it to be effective. The agent has to have, been sent some kind of written notice. It can be an email, it can be a letter. In our office, we send it, usually certified and standard mail just to make sure that they get that document. And we also recommend, if it's ever revoked, that you make sure you send a copy of the revocation to any financial institution or third-party business that may have had a copy on file authorizing the agent to conduct business or banking transactions on your behalf, just so they have it in their system and they're no longer going to honor it. Who can serve as agent? Doesn't need to be a family member. We see mostly family members. Frankly, it's not a, being someone's power of attorney isn't a glamorous job, so it's mostly done by family members who care about and want to help out their older relatives. But it doesn't have to be. There are agencies who will serve as power of attorney, mostly for a fee, but they will do that. So if you don't have anybody in mind, you don't have a family member, it doesn't mean that you can't have a power of attorney. And it does not need to be the eldest child. For some reason, we have clients who think, well, I have to appoint my oldest child as my power of attorney, and no, there's no requirement for that. How to choose a power of attorney. Consider someone you trust. This is, as Katie mentioned in the beginning of the presentation, I work with people who have been exploited or abused, and often it's by someone that they trusted. Most times it's by someone that they trusted. So, and I come from the perspective of, I see, unfortunately, a lot of power of attorney abuse. I see a lot of people who are appointed, who don't have the principal's best interest at heart, and they use that document to exploit the principal. I fully understand that that's not the majority of the cases. The majority of cases, things go smoothly, you appoint someone you trust, and it really is an important document to have in place. So again, if you ever were to not be able to manage your affairs, you have someone designated that can. And it avoids a more complex and, rights restricting process like a guardianship. If you are able to choose a power of attorney while you still have capacity, then you don't have to, if you were to, basically bills got to be paid, right, right up until you pass away. And if someone's not paying those bills, it's likely, and there's no one who has authority to pay those bills, then you could be the subject of a guardianship proceeding. And, that's really kind of a last-ditch effort. Nobody really wants to do that. It's expensive, and it really restricts individual rights. So, it's important to choose someone, but choosing someone you trust. Getting back to, someone you trust, I don't, rarely if I had a client that comes in and says, well, I didn't trust this person, but I still appointed them. So there are some questions you can ask yourself before, when you're considering making this decision. So do they have their own source of income? Frankly, people are less likely to take money that's not theirs if they have their own money. Not that they won't, but, it's just a less likely. Do they answer questions for you? What I say is, when I say that, we go back to your agent is supposed to take direction from you. But sometimes people get a little power hungry. They think they know best, and they're going to answer the questions for you and not let you kind of take the time and respect that you have your own opinions and you can come to your own conclusions. So that's why when our office does powers of attorney in the cases that we do, we always sit down with the principal and speak with them alone. We don't have the agent there, the person they want to appoint, because all too often when I do see cases where powers of attorney have been misused, it was a situation where a client's been in a hospital or a nursing facility, or they were ill, and sometimes it's just necessity. You haven't thought about it, and all of a sudden you're in the hospital and you've got to get it done. And we understand that happens. But sometimes it's, the agent bringing it to the client saying, sign this, make me power of attorney, and not really letting the principal kind of consider it for themselves outside of a crisis situation. That's why we recommend, getting them done early and it being your decision, not someone else saying you should really appoint me. Do they listen and take direction from you? I think I just covered that. Are they forthcoming with information? If you ask them a question, are they responsive? Do they try to hide the ball? Do they say, oh, I'll get back to you on that? They should really, this is a partnership. It's not, it's a partnership. And they should be sharing information with you and making you feel comfortable. So this is a really helpful little guide. The Consumer Financial Protection Bureau, CFPB for short, recently put out a publication called Choosing a Financial Caregiver. And it goes over many different types of financial caregivers. I'm focusing on power of attorney today. But I really like that they put this questions together. And I would encourage, when you're considering it, that you really take some time and look at this, fill it out. Again, do I trust this person? Like I said, very rarely does someone come and say, oh, I didn't trust them, but I appointed them anyways. But that's why they have these other questions, right? Do I feel comfortable sharing my wishes with them? Will they carry out my wishes the way I want them to? Again, a partnership. Choosing someone that you feel comfortable speaking with and that respects you as an individual. They may not agree with something you want, but if you tell them, then they should follow your wishes. Are they willing and able to take on this responsibility? Asking the person if they were interested, able, and willing to help you. This is huge. Agents have to sign this document. Unlike a healthcare proxy, which I was surprised to learn when I started this position, you can just appoint someone your healthcare proxy and they never have to sign it. They might not know about it. But power of attorney requires this individual to sign it. And we have had circumstances where people come to us and they say, I want my daughter. And then we draft the document, send it out to the daughter. Maybe the daughter lives in Ohio. The daughter calls and says, I can't do this. I got too much going on. So it's really important you have a conversation with them. And again, avoid choosing someone who you worry may be struggling with their own financial problems, mental health challenges, gambling, or substance abuse issues. People go through different phases in life. Our loved ones have their own challenges, and it's not, inappropriate or, wrong of you to decide, what, I love this person, I want them in my life, but they might not be the best person that I want to entrust to my finances. That is absolutely fine. And it will save you, potentially a lot of heartache and, a lot of, harm down the road by considering these questions up front. Will they make decisions in my best interest? Caregivers should make decisions that are best for you and avoid conflicts of interest. They should include you in decisions as much as possible. When I say conflicts of interest, again, when cases where I see power of attorney has been misused, it's often by people who become power of attorney and then they'll say, but maybe they're in a position where they need to borrow some money. So they borrow it from the person that they're power of attorney for, right? And that's a conflict of interest. You shouldn't have someone as your agent whom, is also in a position where they are having you co-sign on loans for them or, lending money. That just really muddies the water. It's really important that they keep their money separate and distinct from your money. We see this too with joint bank accounts. Power of attorney is different than having someone as a joint bank account holder. A power of attorney is responsible and has to keep a record of everything that they do for you as power of attorney. A joint bank account holder doesn't. They have access to, if they're added to an account, they can make withdrawals, they can, have a debit card, they can spend money, however, and there's really no oversight. So we do recommend, if someone becomes power of attorney, that you consider, if they're not already a joint account holder, the statute actually recommends that you avoid adding them to a joint account, because then it's a little unclear. Are they acting, when they take money out of a joint account, are they doing that as your power of attorney, or are they doing it as a joint account holder? So again, avoiding those conflicts is really important. Will they manage my money and property carefully? Your caregiver will need to keep a record of all money, property, and debts, invest carefully, pay bills on time, and find out whether you are eligible for any government or employer benefits. It's a lot. Being a power of attorney can be a lot of work. So you want someone who's demonstrated that they can manage your money and property carefully, and as often you can look to see how they're managing their own money and their own property. I do want to address quickly that it is, agents under power of attorney are entitled to reimbursement for expenses they incur. For example, if you have someone who's out of town and they have to drive in and go to banks or something, they're entitled to reimburse themselves from your funds for mileage, for, if they have to hire somebody to do something on your behalf, they're entitled to reimburse themselves from your funds. But if you want to pay someone above and beyond that, you have to actually select that you'd like to compensate them for paying above and beyond reasonable reimbursement for expenses. Again, will they able to keep my money separate from their own? This goes back to joint accounts. Your caregiver should never deposit your money or property into their own or someone else's bank account or investment account. There's clear lines for a reason. There's fiduciary duty for a reason. Keep things separate. And finally, will they keep good records? Your caregiver should keep detailed lists of everything they receive or spend for you. That includes keeping receipts and notes even for small expenses. Some people are really lovely individuals, but they're not great at keeping records. So just, consider it. Is this person gonna keep a record of everything they're doing on my behalf? Because one thing is that they may be called upon by you, by somebody else, to produce an accounting of everything they've done as your power of attorney. And agents should know that, and they should be prepared to provide that accounting. All right, we're going to get into the update section now. Unless, I know, Katie, I said we save them to the end, but are there any relevant questions that we should answer before we get into the updates questions?
I think we're okay to leave it at the end.
Okay. All right, prior to 2010, so I'm going to go POA forms, a brief history. For those on the call today, you may remember prior to 2010, which is only about 11 years ago, POAs were most commonly in a one-page form. They were it was a long page, but it was a one-page. They were simpler, but they left individuals open to exploitation, and they were sometimes referred to as a license to steal. In an effort to protect principals from exploitation, the power of attorney form was updated in 2010. The most significant change was the statutory gifts rider. This meant that if you wanted the individual you appointed as agent to be able to make gifts on your behalf in excess of $500 in a calendar year, you had to do a whole separate form called the statutory gifts rider, which spelled out that gifting authority. That form needed 2 witnesses, disinterested witnesses, so the agent could not be a witness, and otherwise, if you didn't do that, the power of attorney just needed to be signed by the principal and agent, and those signatures had to be notarized. And the goal of this form was just to really ensure principals were aware of the powers they were sharing were more protected. So it went from a one-page form to, if you had the gifts rider, I think the minimum was 9 pages, but, attorneys would put modifications in there, and you were having, documents that were 20, 25 pages long for power of attorney. As I mentioned in the beginning, on June 13th, 2021, the power of attorney form will change again. I'm going to go over and highlight some of those changes and modifications. And as I said in the beginning, as long as they were valid when they were executed, forms done prior to June 13th, 2021 will still be valid. So if you have a one-pager that was done in 2007, even though that's now 2 legislative updates ago, it's still valid. But I wanted to just, focus on the changes, because if you're thinking about doing a power of attorney, or maybe you have one but you want to update it for whatever reason, these are the changes to look out for. So the legislation was actually passed in, I believe it was December 2020, and there was a 6-month period from when it was passed. There were some last-minute amendments that were made to it. The New York State Bar Association has released what they recommend as a template form, but I'm sure every law office is going to have a little bit of a different approach to it. In terms of how they want to word the document. So one of the major changes is that the power of attorney form must substantially conform to the wording in the general obligations law rather than contain the exact wording. That's just a fancy way of saying before, powers of attorney could be rejected if there was even the slightest variation in wording. And now they just have to substantially conform, so it has to be very close, but you can have a misplaced word, and it's not going to invalidate the whole document. It still needs to include the section called caution to the principal, which if you ever do the document, I would encourage you to read. It's long, it's up front, and it's bolded, but it talks to you about what authorities you're giving up and the right to revoke the power of attorney at any time. Any section that is indicated as optional which is not used can be omitted with the words intentionally omitted in place of the section. Optional sections include the modifications. They include compensation for agents, which we touched on, and they include monitor, which is when you can appoint someone to check in on your agent. Before, you had to keep those in there even if you weren't using them, but now you can just intentionally omit them, intentionally omit it in place of the section. This is a really big change. Prior to this change, the principal had to, it was interpreted often that the principal themselves had to sign the document. And sometimes our office has a med law program where we are in hospitals providing legal services to individuals who are hospitalized. Not surprisingly, one of the most frequent requests we have are people who are in a hospital who want to do a power of attorney. And they may have some kind of physical disability which prevents them, they may have had a stroke or, some kind of paralysis which prevents them from being able to sign a document well. And there's all sorts of kind of adaptive devices, there's pens you can, as long as there was a mark in the signature line, they would have to make that mark, but we would do an affidavit saying, we witnessed it, this person was present, they did sign it, they made a mark, it's just not a full signature due to some kind of physical limitation or disability. But the new law allows a third party to sign for the principal at the principal's direction. So again, while it can be beneficial for someone who may have difficulty physically signing, as an attorney who works with people who've been exploited, I'm always a little cautious about somebody signing a document on somebody else's behalf. So a third party, it can't be the agent, so the person you're appointing can't sign on your behalf. It just has to be a third party. But technically, the principal, it doesn't have to be in the same room as the principal when it's signed. The principal can be one area, and as long as the person says, oh no, they told me to sign, it will still be a valid document. So that's something we're watching out for. And I understand the intent behind it. Some of this comes from, the COVID-19 pandemic and the need to do powers of attorney and difficulty, right, getting into nursing facilities to do those. But moving forward, it just makes me a little concerned that someone could sign at the direction of the principal, but there's really no documentation of that direction, There doesn't have to be any sort of documentation that in the they didn't say, oh, they told me to sign. Okay. The statutory gifts rider is eliminated. So there's no longer a separate document just for gifting. If individuals wish to allow for gifting, and the amount of gifting, the minimum has gone from $500 to $5,000. If the agent wants to, or the principal wants to allow the agent to make gifts over $5,000 of their money in a year, they have to include that in the modification section of the actual document itself. And that's just a really important thing to note. You're no longer going to have to do a separate document, but read through that modification section. Make sure that how you want the gifting to be structured is in there. And also, if you want the agent to be able to give gifts to themselves, that has to be spelled out in the modification section. You have to put in there, I want my agent, Jane Doe, I authorize her to give gifts to herself. Otherwise, agents can't do that. They can only give gifts to others. As I mentioned, it's a pretty big jump. It used to be if you wanted to give gifts over $500 in a calendar year, you had to do the statutory gifts rider. Now that's $5,000 a year. So whether or not you even authorize for gifting, when you appoint someone as agent, they are, presumably able to give gifts up to $5,000. It's under the grants of authority section, but and they can give that $5,000, up to themselves. Doesn't have to be other people. That's $5,000. It's only if it's above that amount that you'd want to authorize them to give gifts to, specifically authorize them to give gifts to themselves. So that's just another thing that's a pretty big change from the previous legislation, that extra zero. $500, but $5,000, a lot of money. Another big change, and this is one that, certain organizations really pushed hard for as a modification to the legislation. It must be acknowledged, notarized, and witnessed. So it has to be not acknowledged and notarized by two people who were not named in the instrument as agents or permissible recipients of gifts. So before, as I mentioned, the power of attorney without the gifts rider didn't need a witness, a notary just had to acknowledge the signature of the principal and the agent. But now, every power of attorney has to be witnessed by two people. One can be the attorney preparing the document, and they can also notarize the signatures, but there has to be another individual there who is not the agent and not someone who might be listed as a permissible recipient of a gift. They can't have a motivation themselves. So that's something to keep in mind. It has to be two witnesses now. Agents now have to sign and date their acknowledgement in front of a notary public. Previously, agents didn't have to date the document. The notary public had to date, notary block has a date of the witness and of the signature, but the agent themselves didn't have to date. Now they have to. And third parties, this mostly, the intent of this was to apply to financial institutions. One of the motivations, legislative justifications for updating the power of attorney form was there was this belief that it was regularly refused and that banks would just refuse these otherwise valid forms for no reason. So what the new legislation does is it says if third parties who refuse to honor a POA, they can be financially sanctioned for failure to notify the agent within 10 business days of receiving the documents that A, they are refusing to honor it, and B, why they're refusing to honor it. So, for example, if you're agent for someone and you take the document to a bank and say, all right, I'd like to be added to the account, the institution has 10 days to really either accept or reject that document. And if they reject it, they have to tell you why in writing. This, in most cases, again, this is fine, but there are certain cases where I might have a suspicion that somebody's misusing a power of attorney and might not want to honor it. But the law requires you put in writing, why you're not honoring it. So that's, a lot of this is going to be litigated. Fancy way of saying people are going to get sued. All right, there's going to be a lot of lawsuits brought for this stuff, and we're going to have to let the courts kind of figure it out on both sides, So yeah, some takeaways. So starting in June 13th, they may look slightly different. Again, old forms still valid. And I wouldn't be doing my job if I didn't say, if you have suspicions or something happens, it doesn't seem right, watch out for concerns of exploitation and elder abuse. And a little plug for CELD on that vein. We're based in Buffalo. Our office is right at 438 Main Street. We're at the corner of Main and Court. We also have offices in Lockport and Dunkirk. We serve 11 counties in western New York. I know this is Erie County, so I'm focusing on Erie. We have some of our programs have income or age restrictions. Many of our services require you to be 60 or over. And some require, we have certain income restrictions. You can't, but many of our programs do not. If you have questions about CELD or want to learn more, we have a really great website. We also have Facebook. So feel free to check us out. Not only do we have more information, but we have some blogs. We have some, we've got a lot of units that do a lot of things. So take some time if you want to check us out. We have a free senior legal advice helpline. If you just have a question and you don't really want to open up a whole file, we have a free helpline. It's live attorney from 9 a.m. to 11 a.m. Monday through Friday. And if you call outside of those hours and you leave a voicemail, someone will get back to you within 48 business hours. We also have an email. You can email. So again, that's a free, not full scope service. It's limited scope, but we can definitely give you some free legal advice. All of our services, incidentally, are free, not just the helpline. Should mention that for all of our services are free. I mentioned we're at 438 Main Street. The main intake line is 853-3087. If you have questions for me, my extension is 225, and my email's on there as well. So yeah, we have, I think, a couple of minutes for questions. If we have any, I'm happy to answer them.
Thank you, Sarah. We have several questions, but first we have a couple folks calling in. So could you ever go back and just read off the legal helpline phone number, please?
Oh, sure. I will leave it on the helpline phone number.
Will you read it for the people who are calling in because they can't see it?
Oh, I apologize.
It's okay.
Okay, we cut out for a second. I think it's the phone. Sorry. Our helpline number is 1-844-481-0973. Again, that's 844-481-0973 for our free helpline.
Thank you, Sarah. So this first question here is, are there any liabilities that the POA can face? Example, if the compromised person who needs help hasn't paid bills in the past or has avoided paying the proper taxes, etc., can the POA be held liable?
So the power of attorney, as long as you are acting within your fiduciary duty to the principal, you can't be liable if they didn't pay bills. For example, if they didn't pay their electric bill, the electric company is not going to come after you and say, well, now you're personally responsible because they didn't pay their electric bill. The bills are still in their name. But you do have, a fiduciary duty, which we went over, to, again, act at their direction, or if they're unable to give direction, in their best interest. If you fail to meet that duty, then, you could, or if money is misappropriated, or, records aren't properly kept, then, you could be asked to certainly provide an accounting, and if the accounting isn't sufficient, or if money's been missing, you could be asked certainly to return those funds. But for most cases, if you're appointed and things are, frankly, there's a bit of a financial mess, you're not going to be held liable if they didn't pay their bills prior to you being appointed.
Okay. Thank you, Sarah. The next one is, does power of attorney have an obligation to the rest of the family to report the health of the client?
Great question. As in the beginning, power of attorney is for financial decisions. Healthcare proxy is really the document that has to do with healthcare decisions. So no, not only does the power of attorney not have an obligation to report the health of the individual to the rest of the family, the power of attorney does not necessarily know the health of the individual, because unless they are also healthcare proxy, the power of attorney document itself does not entitle them to know about the health of an individual. Now, I can see there's no legal obligation, to report the health of the rest of the family. But I can understand how in some familial structures, if you're a power of attorney, people may be looking to you and thinking, well, you're power of attorney, so you have to do this or that. But it really is, again, it's a document of financial decisions. It doesn't have anything to do with healthcare. People may think you have to because you're the power of attorney. That's usually a position of trust. But no, there's no legal obligation to keep family members updated on the health of the person who is the principal.
Thank you, Sarah. The next one is, please make the form questions to ask when choosing a caregiver available. So if you have that, if you could email that to me, or just give me a website, I can email that out to everybody. I really like that.
Yeah, it's part of a 4-page PDF from the Consumer Financial Protection Bureau, which I will email the PDF to you, Katie, but it's part of their Managing Someone Else's Money series, which is one of my favorite series. Great resource, and I will email it to you, Katie, the PDF, so you can circulate it to attendees today.
That would be awesome. Thanks, Sarah. This next question is this Senate Bill S as in Sam 888 state or federal?
Great question. That is a state bill. So power of attorney varies by state. There's no federal power of attorney. And actually that gets kind of complex because a power of attorney, because it's a state form and it's governed by state laws and regulations, you can be someone's power of attorney but not have authority to manage their Social Security benefits, even if that's their only source of income. So you may have to, in addition to be power of attorney, and if the person loses capacity, you may have to apply to be their Social Security representative payee, which allows you to have someone's Social Security deposited into an account that is in their name, but is your rep payee for them. Because if you go to the Social Security Administration and say, I have a question about my mom's Social Security benefits, here's my power of attorney, they're going to say, well, we don't accept that. We're a federal institution, and that's a state form. So you have to get the federal authority. Same with VA benefits, the VA benefits for veterans. You have to be a VA fiduciary to really speak with and work with the VA on someone's behalf for their VA benefits. So that was a really great question. Thank you for that question.
I agree. Thanks, Sarah. This next one is Is an indefinite power of attorney from 1970s, which is registered in the clerk's office, still good?
My answer is if it was valid at the time it was executed, then it would still be valid today. There's been no legislation to my knowledge that's been passed that would invalidate any prior powers of attorney. I've never heard the term indefinite power of attorney. We use the term really durable power of attorney. Durable power of attorney means that the power of attorney is still valid even if the principal loses capacity. And that's what the term durable means. You may also hear the term springing power of attorney, which means it only is in effect if the principal loses capacity. And those forms are still kind of float around out there. But the vast majority of powers of attorney that are done today are durable and are valid from the date of signing. So it's not like you sign it as the principal and then it only goes into effect if you lose your capacity. No, it's valid from the moment you sign it. That agent has access and authority to act from the moment it's signed. So while I've never heard the term indefinite, probably wouldn't have because I wasn't alive in 1970, much less practicing. But presuming it was valid in 1970 when drafted, I'm not aware of anything in legislation from 2010 or now that would invalidate any prior powers of attorney.
Thank you, Sarah. And just a follow-up question of my own based on what you said. So if I have a power of attorney, just to clarify, I can still access my finances and conduct my own business, correct?
Exactly, yes. By granting the authority to somebody else, it does not mean you can't access your bank accounts, and frankly, you still should. You should check your statements. You should be aware of what's going on. But just know that that agent, when you sign it and the agent signs it, they also have that authority. Goes back to fiduciary duty. They have to act at your direction. So conceivably, if you say to them, I don't want you to do anything, I want to handle it all myself, they should follow that direction. But they can still be listed as your power of attorney. They can request statements. They can conduct transactions on your behalf. You do not have to be incapacitated for them to take on that role.
Thanks, Sarah. We have a couple more things here. Is that okay?
Yeah.
Okay. This next is two-part question. First, will the slides from this presentation be made available afterwards?
Well, I don't have a problem. I believe it's being recorded, right? Mm-hmm. Katie, are they asking that I share the slides?
I think so, in addition to the recording. Yeah, but the recording, if that's not okay, then we can revisit that because that might be a big file to send out in addition to the handout, but we can figure it out.
Yeah, I would just have to probably clear that with someone else in our office if we can make the PowerPoint widely available.
Okay, that's fine. The second part is, after a POA is executed, what do you do with the document? Who needs to receive it?
Oh, again, great question. So I would highly recommend that you consult with an attorney to do this document. And each attorney's office is going to have their different kind of practice, but I will tell you what ours is. We have the original document. You may elect to file the original document with the Genesee County, or sorry, not Genesee County, with the county clerk's office, any county clerk's office in which the document with executor will be used. You do not have to do that. The only time the original has to be filed is if the agent is making a real property transaction on your behalf. But we recommend that the principal keep the original in a safe place. We also provide the principal with 5 attorney certified copies because many financial institutions won't just accept like a scanned copy or a copy without some kind of certification on it of the document, and that's within their rights. They can require that it be a certified copy. So we make a minimum of 5 certified copies. We send them to the principal, and then we leave it up to the principal to decide if they want the agent to get those copies. But conceivably, what ideally happens is that the principal receives them, gives them copies to the agent, and the agent would present a copy to wherever banking is done. They could send a copy if the individual has like an IRA, or if anytime they need to conduct business on behalf of that principal, they have a certified copy they can present. So there's no hard and fast rule of everyone who needs immediately to get a copy of that power of attorney, but it's just important that these certified copies are available, and that the principal keeps the original in case additionally certified copies need to be made, and that whoever needs to really view the document can have it. And not everyone requires a certified copy. Like our office, we don't require a certified copy. A scanned copy is fine for us. But certain institutions require that extra layer of authentication before they'll accept that document.
All right, thanks, Sarah. I know we're coming up on time here. We just have 2 more things. This one is, my mom has not used her Visa card in over 7 years. She wanted to cancel it. I am her POA. I sent it to Visa from Bank of America. All the needed papers and proof that were needed included a copy of the POA. They refused her power of attorney because they said it was outdated. The date of the POA was 2001, and this person has been using the POA for everything prior to this. They're wondering, do I have any recourse for this? It was over $200 to set up a new power of attorney, and at the time, Mom said, no way.
So that's a great question. That's one of those things that's probably going to be tested under this new law. Although Visa did reply and say why they're not accepting it, under the new law, if the attorney who did that power of attorney is still around, or if the agent can respond in writing to kind of refute that and say, well, under New York law, there's no power of attorney, there's no expiration date. This is not a reasonable refusal. This may be this may be Visa's approach, but in New York state law, it's still valid. So it kind of allows for that back and forth in an attempt to cure the reason that they're rejecting it. And so the new law does address that, and it makes it more difficult for financial institutions or credit card companies to just flatly reject it and say, well, we're not going to honor this. Ultimately, it's up to them, but if they refused to, and there was some kind of financial damages that incurred because of their refusal to honor it, and that refusal wasn't reasonable, then they could be, you can go after them for damages now. Fancy way of saying they may have to pay out if they refuse to honor these documents, and that may change their calculation a little bit, both good and bad ways, about whether or not they're going to refuse to honor powers of attorney. So you might want to try again after the 13th when the New York law takes effect, to send it in again and say, no, I still want this done, and then see what they come back with. And again, there's a now they have to review it if you put it in writing, or especially if the attorney who did it is still around, or any attorney, to put in writing why they have to accept it.
Thank you, Sarah. This next thing is, this person's just wondering if you can give the New York State Senate bill number again. I just want to make sure they get the right information.
Yes, I can do that. So the Senate bill is S-888. And that would have been from the 2020 legislative session.
Thank you. And I know we're at 11 o'clock here, but I just have a quick question in honor of World Elder Abuse Awareness Day on June 15th. Sarah, if I suspect or I'm concerned about my power of attorney and what they're doing with my money, what's the first step I should take? Do you recommend?
So if you're concerned about the power of attorney, what they're doing with your money, I would recommend, two things. If you're concerned, as the individual, call our office. Call me, call Center for Elder Law and Justice. We handle those cases all the time, and we can explain, you can go through the steps that you may wish to take, including, do you just want to request an accounting? Do you want them to help get your statements and go through them up through into revocation of the document? If you're concerned about exploitation for somebody else, so if you have a friend or family member and you think that, they're being exploited by their power of attorney, I just want to caution that our office, we always need to speak with the principal. We need to speak with the actual potential victim. So unless that potential victim wants to talk with us, then your best bet would probably be to reach out to Adult Protective Services. The number is 858-6877. And if you suspect abuse, but it's not you're not the person calling for help on your behalf. If you're calling for somebody else, I would reach out to Adult Protective Services first.
All right, thank you, Sarah. I'm not seeing any other questions come in. I'm just seeing a bunch of thank yous. So thank you for your time today, Sarah, and thank you to everyone who's on. I'll get that information out to you in the near future.
All right, thank you, Katie. Have a great day.
All right, you too. Bye.